So, good evening, and thank you for joining us for this webinar session, The Metaverse, Is It For You? We hope you will find it informative and interesting. Some introductions first. I'm Claire Lair. I'm a partner at Edwin Co in the IP team. I specialise in trademarks, their prosecution and protection from searching through to disputes. My partner, Nick Phillips, is also in the IP team here at Edwin Co. Nick is a highly experienced IP lawyer with a focus on commercialisation of IP. Nick will be talking to us about the commercial aspects of law which companies should consider as they venture into this new world. Nick is recommended in the Legal 500 2023. Our guest speaker, Patrick Juarez Pennant, is the Chief Strategy Officer at Wild Bytes, an extraordinarily innovative advertising agency with a Spanish, German, and US presence. Working with clients such as Zara, Dior, and H&M, Wild Bytes has helped many other companies to gain a real, if you'll excuse that word in a Metaverse webinar, and strong Metaverse presence. Lastly, a housekeeping point. We're going to be taking questions through the Q&A function on Zoom this evening. Please do send in your questions and we'll try and answer as many of them as possible at the end of the webinar. If there is time, we'll try and answer one or two quick questions at the end of each session. But if we don't get to your question, or if you've got further questions at the end, please do get in contact with us via email through the details provided on the last slide of the webinar. So let's get started. Patrick is going to start the webinar and is going to talk to us about why brands are entering the metaverse and sharing some of his experiences in this new world. Patrick, thank you so much for joining us this evening, and over to you.
Hello, how is everybody? Nice to have you, and thank you, Claire, for having me. Let's get into our presentation. First slide, please. Next slide, please. Yes. So, virtual spaces and Metaverse. Why do we want to be part of it? And why does this happen? Basically, because these are 3D spaces where we want to have representation of an avatar. And I like to call it not the metaverse, but the betterverse, which is an extended reality which enhances the universe. Next slide, please. Why should a brand enter the metaverse, and what's the value? Well, basically, is it a buzzword or is it here to stay? Obviously, it's not a hot term trend, but it's definitely here to stay. And if we see that there's an exchange or a monetization scenario, that is why we want to be part of it. Next slide, please. Ultimately, what we're trying to do is enhance brand image and create revenue drivers. In 2007, we had a first instance with Second Life, but then that led to being a platform that would later take us to Fortnite, which was a huge success. So is it geeky or is it mainstream? Well, Metaverse has definitely carved the path for gaming, art, and fashion. Next slide, please. And it's here to stay because Generation Z has been working on it and living in it since 2018. They've been on it in video games and sharing with friends online. So we definitely need to find ways to be in communication and contact with them in order to really instill a different way of consumption. Next slide, please. So why is it important to have brand image explode in the metaverse? Number one, the PR splash. The PR splash is key because brands that want to be the first to be there will always attract attention to new consumers, especially consumers from other generations and younger generations. And also for the long-term strategy. If you work in the fashion industry, automobile, or even industry, the sooner you're part of the metaverse, the better it is for your brand to be exposed to other types of clientele. Next slide, please. Here you have an example of Balenciaga creating a joint venture with Fortnite in order to get in touch with and evangelize the brand through different audiences. So let's go to the next slide, please. Here you have another aspect of Metaverse and how we tokenize garments that are digital and placed on physical in order to create other realities and create digital garments that will ultimately dress our avatars, because we will eventually have 2 or 3 avatars that work and delve within different realities. We could have a gym avatar, a working avatar, a nighttime avatar, a daytime avatar, and we will have to dress those and buy digital assets in order to have those up to date. Next slide, please. Why is it a revenue driver? Well, today there's nearly 55 daily active users on Avatar, and basically that's $2 billion a year in revenue as of now. So direct sales from digital assets are definitely something that is going to drive revenues. Indirect physical sales as well create virtual interactions. And then lastly, the fact that we're gathering data to make push within the brand is definitely going to be something that's needed to create value. Because, next slide, please. Because video games are already monetizing it, and the investment in the market is set to multiply by 10 in the next year and a half. And it might hit approximately 800 billion by the end of 2024. Next slide, please. Here we have a case of the Adredder brand joint venturing with Zara and Zepeto, which is a Web3 social media metaverse platform. And what they did is they basically engaged Zara users to a new brand in order to have more users go, number 1, to Zara, number 2, to a new business unit, and number 3, to use Web3 and purchase through other routes of distribution. Next slide, please. Here you have a video of the Adredder brand by Zara. Zara likes to do a lot of spin-offs. We do a lot of spin-offs with Zara. They have Pull and Bear, Bershka, Stradivarius, and we're creating metaverse experiences for all their different business units in order to grow Inditex, which is the ultimate umbrella or holding group of Zara. Next slide, please. So how to enter as a brand? Next slide, please. First, you have to see what others did. If you look into examples like Samsung, Balenciaga, or Nike, Nike is doing something very interesting where they get to gather a community through a company called Artifact, and that community decides to design a special type of sneaker. If that sneaker is followed and approved by more than X amount of people within that community, that sneaker ends up going to physical commercialization, and you get to keep IP and token within the design of that sneaker. So it's basically redoing what Michael Jordan did, but within ourselves in the community. Next slide, please. So you also have to find the right platform, which is very important. Do we want a centralized platform, a decentralized platform? Do we want a content creator platform? Is it more of a developer platform, or do we want it for instructional or educational purposes? Next slide, please. And we also have to define that long-term strategy. For example, with Cupra, which is the luxury brand spinoff of Seat and part of the VW group, we are creating a huge long-term strategy in the metaverse to design and configure their own up-and-coming new automobiles and anybody can jump on the metaverse and try to make their own vehicle by Cupra. Even a 9-year-old can start being part of the Cupra community. This major event will launch this Friday, which is going to be very exciting in Berlin. And I believe 4,000 to 5,000 people will be attending. If you have any questions on that, I'm happy to answer later on. Next slide, please. And you have to keep building. You have to keep changing the strategy, making sure you implement the right tools, then take data to measure who's making the community grow, and then keep continuing on iterating. Next slide, please. So the metaverse is the world, and establishing a presence in the world is very important as of today, because we are not connected within generations the way we used to be. So in order to get rid of the division, brands are using the metaverse to connect younger audiences with the older audiences, to have different types of consumption and reaching better ways of living within different worlds, and understanding that a brand can live anywhere. Next slide, please. And also the people. As I mentioned before, we will have digital twins, avatars, and new identities, which will swim in different platforms within the metaverse worlds. And those will be used for specific things, whether it be for a job interview, whether it be for understanding or buying real estate, or even configuring an automobile for your next purchase. Next slide, please. The property as well is very important. And as I mentioned earlier with Nike, designs and creator communities are coming up with new and different ways of putting together styles and creating their own content. And then what that does is it helps you tap into tokens, which creates NFTs and creates value both in the physical and in the digital world. And then you have passive assets where you can also create circular economy. Next slide, please. What are the challenges and opportunities for creatives? This is very important in the metaverse. Next slide, please. So number one is we get to play in it. So basically the metaverse is the Roblox for adults. So next, please. So as we play in it, we change our mindset. So it feels like we're working, it feels like we're consuming, it feels like we're learning, but in a different set and scope. So it definitely changes the way you see how to consume a product or learn about it. Next slide. And then you also get to understand the context. So not only do we swim in understanding the physical context of things, or the traditional Web 2 social networks aspect of things, but we go a step further and jump into other worlds in order to understand that there's many ways of consumption to reach the same conclusion. Next. And then lastly, we have to choose the right team. Within platforms, when brands want to be part of that platform, we have to make sure that we're choosing the right people that are heavily invested in changing the way the brand wants, what the brand wants to look like in the next 5 to 10 years. Next. And enjoy the front line. Why? Because as Gucci did, or Balenciaga, or Hyundai, or even Zara, many of these, which are our clients today, they were in the front line, and now everybody's looking back and saying, wow, they're really selling and evangelizing their products in a different way, shape, or form. Next slide, please. So what's next for us now in the metaverse? It will become normalized. It will be a place of exchange. Platforms will be connected amongst them because they will be decentralized. So that makes it very interesting. So basically, you will be able to communicate within Roblox, Decentraland, Sandbox, or Fortnite. So that's going to be a lot of fun. Next slide. And as I said before, digital garments are going to be a big deal. So it'll be normal that we dress our avatars and that we dress ourselves within the digital garments to activate different ways of consumption, number one, and different behavioral uh, scope within social and networks and in Web3. Next slide, please. As I mentioned earlier in the conversation, we will be owning several avatars. Why? Because we will be needing several avatars to live in different worlds and experience different aspects, whether it be learning, whether it be selling, whether it be growing, or whether it be finding ways of being in touch with new immersive experiences. Next slide. Everyone will have a wallet and they'll have a variety of digital NFTs. Next slide, please. And then our psychology will keep evolving, which is extremely important. We'll keep changing. We'll keep looking at things in a different way. We'll enjoy things in a different way as well. We'll find ways to be 3D artists, and we'll find new jobs. Like, I'm the chief metaverse officer. I'm a 3D artist in the metaverse. I'm a game developer. I'm a content maker. I'm even in the food tech in the metaverse. So there will be different careers coming from this, which will be great opportunities to enhance the workforce in the world. Next slide, please. So lastly, brands like Adidas have brought and bought lots of plots of land in Sandbox. Warner has also bought real estate in Roblox and in Sandbox as well, and Nike and many other platforms as well, as you know. So basically, the metaverse will be the revolution and part of our lives sooner or later. And this new dimension will definitely transform the way we live. So thank you very much. And please don't miss online our launch of the Cupra vehicle this Friday. Thank you so much.
Thank you so much, Patrick. That was really very interesting and a fascinating trip into the metaverse. I'm just looking at the time. We've got time for one very quick question. Can you give us a very high-level outline of how you assist companies in their debut in the metaverse?
Okay, this is a great question, and this question pops up all the time. It all depends on how big their R&D department is, number one. It depends on the curiosity of the people that lead the creative aspects, operational aspects, and strategy aspects of the company. And it also depends on how large the brand is. So we tend to sway away from companies where their brand is not very big or their product is not highly known, because it probably is not the best result right now to delve into the metaverse. But if you're a Nike, a Richard Ellis, if you are a Volkswagen Group, if you're a Gucci, you definitely have to be in the metaverse. So what we do is, number one, is we always receive pitches from companies, and that the fact that they want to be part of scenarios that have to do with metaverse or new experiences, even in AI. And second, we circle back to them and tell them what's the best platform for them, for their employees, and ultimately for the brand on a long-term strategy.
Amazing. Thank you very much, Patrick. It's really interesting. So, Patrick has given us this exhilarating trip to the metaverse, and it's really quite fascinating what awaits us, or you might even have been in there yourself. It really is a whole new world. I have to say, my presentation is not as exciting as Patrick's. I'm bringing us all down to earth with a look at what is happening with the world that runs parallel to the metaverse, the trademark world. Next slide, please. So Patrick's told us what the metaverse is and how it can be utilised. I'm going to be looking at how the intellectual property offices, the IPOs, have reacted, gallop through some case law There's not very much, so it won't take too long. And I'll finish up with some thoughts about how you and your brand or your client's brand can be protected in the metaverse. So effectively, as we said right at the start, we're dealing with a whole new world. It's a new start, and inevitably there are new rules. So what I'm going to do is take us what it looks like practically in these new rules, what the courts think, and what we can do to protect ourselves and our clients. Next slide, please. So the new world and new rules. The IPOs around the world have reacted as they started to receive an increasing number of trademark applications for metaverse goods or virtual goods in the metaverse. So the IPOs have issued directions. So I've rather bravely put the UK Union Jack between the European Union flag and the United States flag. In fact, the UK IPO was a little bit slower in confirming its position. It wasn't until March this year. The EU IPO and the US PTO and the Benelux office and the Brazilian office were all a little bit quicker off the mark, and they issued their statements in 2022. But importantly, they've all been very consistent in saying that virtual goods belong in class 9, which is the software class. Next slide, please. So I thought it would be interesting to have a look at an actual specification for showing virtual goods and services. So Patrick has showed us that virtual goods can be absolutely anything: training shoes, t-shirt, cars, sports equipment, burgers, plates, houses, furnishing, and land. They're all virtual, so they're all software, and that includes the NFTs. So the IPOs have been saying that the type of virtual goods, and including the goods that are authenticated by NFTs, must be specified. And for those who work with the EU IPO, you'll know that the EU IPO has always been very keen on having precision and clarity in its specifications. So there's nothing new in this. Let's look at the McDonald's specification. So in class 9, we have virtual food and beverages, and I have to do a little bit of blink there to start off with, because you think food and beverages, why are they in class 9? Of course they are, they're virtual. Then you look at the class 41 services. I think these are actually quite interesting. You can go to a virtual restaurant and you can wear McDonald's clothing if you want to. You can actually attend a virtual or an actual concert. And look at that specification in 41, the last term: operating a virtual restaurant featuring virtual home delivery. And then go down to the class 43, and here's the blend of the worlds that Patrick was talking about earlier: operating a virtual restaurant featuring actual home delivery. So quite amazing. Here's the IPOs reacting, and you can see that in the specifications. Next slide, please. So here we have the another specification. This one is actually a very long specification. It belongs to Gucci, and you can see the Gucci interlocking G's there on the right. I've cut down the specification simply because it's too long to put on. But if you look in class 9, you can see that they have these downloadable virtual goods with a number of assets. And here is Patrick's real estate, lands, all for use in online games. And look, there's that wording, also being authenticated by NFTs. Look at the class 35. Here you are again. There's the first term, online retail store services featuring games and stores. There's nothing too exciting about that. But look at the next one, online retail store services featuring virtual assets. virtual real estate and lands, and there is the authentication by NFTs again. So I think it's a very, very interesting specification. Let's have a look at what the courts are saying now that we've looked at what the IPOs have said. So the IPOs have said that protection is to be given to virtual goods and services. But what if you're not in the metaverse? What if you're selling actual clothing, actual cars? So you've got, for example, registrations in class 25 for clothing, class 12 for vehicles, and you may well have as well class 35 services, online retail and retail store services. So you're fine, aren't you? Or what if you've ventured into the metaverse and you're selling your virtual goods and you've got virtual protection? Sorry, you've got traditional protection. So that, by that, I mean the class 12, the class 25. Again, you're fine, aren't you? Well, we know what the IPOs have said. They've said very clearly that virtual protection is class 9 for virtual goods. What's the case law? What do the courts say? Well, there's not too much. I told you that at the beginning. So this case, the Hermes and Mason Rothschild, there's been a lot written about this one. I can only, in the time allocated, give a very high-level summary. Clearly, Hermes Birkin bag is on the left, and the Meta Birkin, the furry and colourful bag, is on the right. I think it's fair to say it's not quite in Hermes' usual style. So in this case, Mason Rothschild created NFTs linking to a description of a digital Hermes Birkin bag. And he also registered and used the domain name www.metabirkin.com and social media handles such as @MetaBirkins to promote the sale of his NFTs, the Meta Birkin, so-called Meta Birkin NFTs. And he sold over $1 million worth of these. Hermes were understandably a bit cross. The Birkin bag is highly exclusive. There's a restrictive purchasing ability to it. And of course, it's extremely expensive as well. So Hermes obviously got trademark protection for it in class 18. Class 18 is for actual goods, including, of course, for handbags. But the IPOs, as we've just discussed, have said that virtual handbags belong in class 9. So what happened? Well, to cut a very long story short, the court in this case held that despite not having class 9 protection, Hermes' reputation in the Birkin bag carried over into virtual goods, virtual handbags. And so Hermes prevailed in this case. Next slide, please. So this is the second case. Again, I can only give a very high level summary to it. This is the Juventus Football Club and Blockerus. In this case, Juventus brought a claim against Blockerus, who were also producing, creating and selling NFTs. And these NFTs use Juventus's mark. So Juventus, Juve, and the design of the black and white football team stripe. The NFTs were linked to trading cards, and these featured the former Juventus striker Christian Vieri. So Juventus also were not very happy, and they filed infringement proceedings claiming infringement of the club's registered marks. Notably, Juventus, just like Hermes, did have trademark registrations for its marks, but they weren't in class 9. So again, this is a very similar situation. The court in this case also held in favour of the brand owner, Juventus, and they found that the marks was the goods, the virtual goods, were sufficiently protected through their existing traditional trademark registrations. And quite crucially, I think, Juventus had filed sufficient evidence to demonstrate that its marks were well known. And so they had enhanced protection, and that moved then into Class 9, and it covered goods and services where they didn't have registered protection. So you might be thinking, do we need Class 9? Well, the limited case law looks as if you don't, if you've got a famous or a well-known brand. But I think that's a bit of a risk, personally. What if your brand isn't famous or isn't well-known? That's, to me, quite a tricky question. And I think at this point in time, it's quite difficult to know how a court might decide. So let's say you've got a less well-known brand, but like Hermes and Juventus, you've also got traditional trademark protection. So you might have a Class 18 registration if you're in handbags, or as we said, 25 for clothing, or 12 for vehicles. And you might also have Class 35 for online and in-store sales. So is your traditional trademark protection going to be sufficient to deal with an infringer in the metaverse using your brand? We don't have a case for this scenario yet. And there isn't, as far as I know, a comparable opposition at an IPO where that particular situation has been tested. I suspect with no Class 9, no virtual goods, or no virtual goods wording in a Class 35 retail specification, you could be in for quite an unpleasant surprise, having in mind what the IPOs have said. So this becomes a bit about an appetite, your appetite or client's appetite for risk. Next slide, please. And is it worth the risk? Well, a Class 9 filing will give you better protection, enhanced protection. And what we know from the case so far seems to be that if your brand is well known, then you are probably okay. But there's only 2 cases so far. But if you're not famous and you're not well known, then my view will be to err on the side of caution. And you know, these bigger, well-known brands are doing the same. They're also being cautious because, as we've seen, they're busy out there and they're filing and registering trademarks in Class 9 for virtual goods and in other classes as well. So it's not just about risk, it's about costs as well, because filing a trademark application is much cheaper than scrambling and trying to collate your evidence in a case to rely on in an unregistered rights case, where you have to have the evidence to prove your reputation and to prove that your brand is sufficiently well known. And of course, with a trademark registration in Class 9, you don't have to do that. So we've got Class 9 giving you that extra layer of protection, and I would also bolt on virtual retail services in Class 35 as well. So what can you be doing at this point in time? You probably are doing a regular audit of your trademarks. Are your rights up to date? Have you got your latest logo registered? Have you expanded into new products? Have you got trademark protection for those new products? As I said, you're likely doing this, but now bolt on that virtual audit as well. If you think that you are going into the metaverse, or you're concerned about your brand being used without your authority in the metaverse, then my feeling is that you should be filing in Class 9 and in Class 35 so that you are prepared for entering into this new world. So we have one question that I think we have time for. Is there any way I can expand my existing trademarks to cover the metaverse? I'm afraid the answer to that question is no. You can't actually expand an existing trademark registration. You are going to have to refile for a new application which covers the virtual goods and services for which you would like protection. So I think that we don't have time for oh no, we do have time. So another question, if your mark is not famous and you do have Class 9 to cover metaverse use, but the mark is not actually used virtually, is there an issue for cancellation for non-use if your mark hasn't been used virtually for, say, 5 years? I think the answer to that has to be probably yes. We're a long way off that because most of the metaverse registrations that I've seen have been actually filed within the last year. So we're some time away from that. But I think the basic trademark rules are going to apply. If you don't use, you're going to lose it. So with that, I'm going to hand on to Nick, who's going to talk to us about commercialization in the metaverse. Nick.
Thanks, Claire, and thanks, Patrick, too. So I'm going to build a little bit on what Claire has talked about. So Claire's talked about trademark issues around doing business in the metaverse. And I'm going to talk more generally about legal issues and other things to consider before you do business in the metaverse. So if I can have the first slide, please. So if we think about the metaverse as a fully immersive digital world where people can work, play, and even live, a question that comes up fairly early on is what law applies to those fully immersive digital worlds. So if something goes wrong in one of those worlds, if there's a dispute between people living or working or playing in those worlds, what law do you turn to resolve those disputes? Now, I think part of the answer to that is to be found if you look at the terms of use or the platform terms that, generally speaking, you will click to accept before you enter one of these worlds. So I've put up on the first slide there a link to the Pixie Links terms and conditions, and also a link to Decentraland. But both of those are fairly well-known metaverses, and Decentraland is actually the world's largest decentralized metaverse. Now, if you have a moment to look at those after this webinar, what you will see is that there's actually nothing very remarkable about those terms and conditions. They are really the same kind of terms and conditions as you would expect every time you sign up to a technology product or a technology service. They're sort of disclaiming liability and they're limiting down warranties as much as possible. But what they have, or certainly what Decentraland has as well, is a fairly well-developed content policy, or what I would call an acceptable use policy. And what that does is it sort of sets out some rules for how you must behave on Decentraland, and essentially what you can and cannot do. So, for example, it talks about not introducing illegal content, no libelous content, no hate speech, no hate content, and it places restrictions on other types of content, such as gambling-related content. But I think even that sort of content policy is not particularly unusual, and it's the kind of thing that I would expect to see if I signed up to a sort of social media site or any other site which was accepting or allowing user-generated content. But I think what we're going to see in the metaverse is these acceptable use policies, these content policies, really being expanded, really growing, until they almost become a set of private laws, and private laws which really govern life in those fully immersive digital worlds or metaverses. So I think that's what we're likely to see. But even with the most sophisticated set of private laws, it's also inevitable that those disputes are going to spill out into the real world. So they might be disputes about virtual goods, might be disputes about virtual virtual property, and they may even be disputes about civil and criminal wrongs which were committed in the metaverse. So the question then becomes, whose courts do you look at to decide that those sorts of cases? And what we've seen so far is those cases being determined, being tried in the courts where the platform provider, where the service provider is based. So typically where their servers are or where they're based. But even that may not be the greatest solution. Sometimes that may not be suitable, may not be acceptable. And on other occasions, it may just be difficult to work out exactly where that platform operates. So another idea would be to look where the user or the avatar is actually based. And I think also going forward, what we're going to see is a development of either case law and or regulation, which is really helping us, telling us where to bring those sort of cases which originate in the metaverse. So that's something to look out for. If I can have the next slide, please. The metaverse is, in many ways, a bit of a gift for lawyers, absolutely bristling with potential issues, potential legal issues. And I've put some of them on the slide there. I mean, some of them are very real, very practical, and others are a bit more hypothetical, a bit more academic, at least at this fairly early stage. But for today, with limited time, I'm going to concentrate more on IP and intellectual property agreements, and maybe touch slightly on data privacy as well. So if we can move on to the next slide, please. So I've set out there a fairly typical grant of license clause from an IP agreement. This one is actually a license of copyright. So what you've got going on there is the licensor granting to the licensee a license under its copyright to do certain acts in the territory. Now, just make two observations about that sort of clause related to the metaverse. The first one, I suppose the most obvious one, is the definition of territory, because territory is traditionally defined as a country or countries, could be the UK, could be the European Union, or even the world. So the first question becomes, does territory include the metaverse? Which I think at best is going to be arguable, is going to be ambiguous, and I think is even more difficult where you start talking about a world which is kind of semi-virtual, semi-real, perhaps if you're using augmented reality to generate that world. But that's that sort of problem with new technology challenging, stretching the words in contracts is not a particularly new one. And we've certainly seen that's the same sort of problem with all sorts of new technology, DVDs, CDs, and I'm also just about old enough to remember that when entertainment in air traffic became a real thing, there was a real tendency to sort of take that flight entertainment and to deal with it separately to rights in sort of more traditional areas. And the other thing I think to say is, looking at this clause, the scope of use, so where that copyright can be used by the licensee, is fairly wide. maybe it's a bit wider than most licensors would like. But I think that need to narrow the scope of use is going to be much more of an issue when we get into the metaverse. So, for example, if you think about a children's brand or a brand which is really aimed predominantly at children, you're really not going to want that brand to be used in unsuitable contexts, such as games depicting violence or sex. So you're going to want to prescribe in your license agreement what can and cannot be done with that copyright or with that IP right. So bring up the next slide, please. So yeah, so staying with IP agreements, I think the main thing is you've got to be looking at your IP agreements and working out whether they are really suitable for the metaverse. As I say, definition of territory is going to be a big issue. You need to make sure that works, and you try and remove the ambiguity for the metaverse. From a licensor's point of view, I think what we may see, and indeed what we're beginning to see in some aspects, is a move toward licensors licensing the metaverse separately. So almost treating the metaverse as a separate country, a separate territory, and dealing with that separately, and then dealing with sort of traditional real worlds, real territories in separate or under separate licensing arrangements. The licensee fundamentally is going to want certainty. So it's going to want to ensure that the definition of territory is wide enough, is robust enough to ensure that it can do what it needs to do or what it wants to do, not just in the metaverse as it exists today, but in the metaverse, as it may expand. So there needs to be a certain element of future-proofing there in that definition. But I think whether you're the licensor or whether you're the licensee, the key thing really is to call out metaverse specifically and really get into whether or not that's covered. Scope of use, dealt with that already, so I'll move through that. And then I think a big issue is going to be ownership of IP and identifying the licensor. So I think increasingly we're going to see IP, whether that's content or whatever, which is either created by artificial intelligence, and it's going to be difficult to work out who the owner is, who you're taking the license from, or it's going to be created as the result of collaborations. And one thing that we are seeing from the metaverse is businesses who wouldn't previously have thought about collaborating suddenly find it really useful, really convenient to collaborate in the metaverse. So there's going to be some issues around the ownership of that kind of IP as well. Quickly talk about term and termination. I suspect that what's going to happen with the metaverse is that because it's so sort of quick moving, so rapidly evolving, there's going to be a move towards either shorter license terms, project-specific license terms, or at the very least, license terms which are regularly reviewed to see if they're still sort of fit for purpose. I think that's a trend we're beginning to see already. And then finally, royalties. I think royalty models are going to have to be reviewed. We're certainly seeing a move towards smart contracts where the IP owner, the IP user is automatically compensated every time the IP is used. But I think in addition to that, we may well find ourselves looking a bit more at a kind of influencer type model where there's a bit more of a premium on user engagement as well as simply sort of sales of products, sales of services. So I think we're going to see that kind of thing coming in as well. We can have the next slide, please. So yeah, I haven't really got a huge amount of time to look at all of the various data privacy possibilities, but I was going to just touch on a couple which I think are important, and I think also data privacy is going to be very important in the metaverse. And the first thing I wanted just to talk about is the nature of the metaverse, which I think is going to make it very difficult to identify who is who and who is doing what. So, data privacy lawyers will know it's always very important to identify who the data controller is and who the data processor is, so you can tell who's doing what, who, for example, is going to be in charge of putting up the privacy notice or the privacy policy, who's gathering the consent, and so on. But in the metaverse, what you're going to have is a multitude of entities with very different, often complex relationships, which I think is going to make it very difficult to identify those individual roles. Go to the next slide, please. And the other data privacy issue I was going to talk about is if, like me, you think about the metaverse along the lines of the film Ready Player One. So with everybody running around with virtual reality headsets and wearing haptic suits, what's obvious from that, or what's going to happen there in data privacy terms, is that we are going to see a huge amount of personal data being collected through those headsets and through those suits. And not only is there a huge amount of data being collected, but also quite a lot of that data is potentially going to be special category data. So, for example, if you're creating a fairly lifelike avatar, perhaps an avatar you're going to use in a workplace scenario, or if your data is being collected about your physiological reaction to experiences in the metaverse, that is fairly likely to be special category data. And the problem that arises there is that a requirement to processing that special category data is nearly always going to be explicit consent. And then you have questions around how specific does that consent need to be? So, for example, do you just get consent once when the person enters the metaverse or their data is collected, or do you need to get consent for different uses? So let's say when an avatar goes to an art gallery or attends a pop concert or goes to an auction, do you need different consents for all of those different types of uses? So lots of data privacy related questions. We have the next slide, please. So I think I have very largely run out of time. I might just have time just to look and see if there is a question, which I don't think there is. So let me just wrap up generally, and then I can bring back Patrick and Claire to answer any questions that have been added on their bits while I've been talking. So I think what I've taken from both what I know about the metaverse and particularly from this evening are really the following things. So the metaverse is very much a real thing. It's happening now. There are big brands out there really sort of exploiting, using the metaverse. So it's something not to be ignored. And then the second thing is that clearly there are lots of different metaverses, and those metaverses have different applications and may well be suitable for different types of businesses. And then when it comes to trademarks, it's really important to review your trademark portfolio and make sure that it's suitable for the metaverse. And that applies equally to whether you've got any intention to enter the metaverse, or whether you just want it as whether you want your trademark as almost a defensive registration to stop other people using your brands in the metaverse. And then looking at IP agreements, I think the key thing here is really to review your current IP agreements, review your templates, and ensure that they are really suitable for the metaverse enabled world. So if, I suppose, little plug for Patrick, if you are thinking of going into the metaverse, if you need some help about entering the metaverse, maybe you're not sure about what kind of metaverse you should be going into, then please do reach out to Patrick. And then also for more sort of legal trademark issues, please do get in contact with Claire or I, and we'd be delighted to help you or try to help you.
Very much.
Actually, sorry,
Nick, I've just seen that there are 2 questions for you in the question and answer. The first one is, I've heard the GDPR might be a bit of a roadblock for the operation of the metaverse. What are your thoughts on that?
Yeah, that is something which is sort of bandied around quite a lot, and I think the argument really is that because the GDPR has a sort of extraterritorial element, if you are a non-EU based platform provider, so if you are running a sort of non-EU based metaverse, you may be reluctant to allow into your metaverse lots of EU-based users or indeed UK-based users, EU or UK-based avatars, because by doing that, what you're doing is exposing yourself to the sort of greater rigor of the GDPR. Now, I'm not sure if that, I don't think that's going to be right for 2 reasons. Firstly, I mean, what we've seen already in the metaverse, but also more generally, is that people based outside of Europe, outside of the UK, are generally prepared to embrace the sort of stricter regime of the GDPR, almost as sort of a cost of doing business on the internet or in the metaverse. And I think secondly, while at one time the GDPR was very much the sort of gold standard of data privacy, and maybe it still is, the rest of the world is catching up. So we are seeing an awful lot of GDPR-based data privacy regimes. We've got the one in New York, we've got one in California, Canada, and many other countries like Brazil are bringing in GDPR-style data privacy regimes. So I think the answer to that is unlikely.
Okay, thank you. I've got a question for me. Are there any particular countries I should be looking to register my trademarks in if I want to protect my brand in the metaverse? I think this is an excellent question, given that there isn't a trademark territory, the metaverse. So my feeling on this would be that you register where you normally would do. So if you are based in the US, I would go for the US. If you have any trade in the European Union or Brazil, the UK, I would register in those territories where you normally would. You are not, unless you are an extremely wealthy corporation, going to be able to register your trademark in absolutely every single territory in the world. There are very, very few companies that do that. So I think a practical approach, register where you normally would and take it from there, I'm afraid is the best answer that I can give at the moment. Nick, there's another question for you. This one is, given there's a new world out there, do you think companies should think in terms of agreements solely governing their business in the metaverse?
I think, as I've said, I think that at the very least, businesses should be reviewing existing contracts and making sure that they are sort of metaverse compatible and trying to introduce a sort of an element of future proofing. I'm not sure if it necessarily follows that you have to have metaverse specific contracts, but commercially, it may well be a good idea to split out the metaverse, which may well have a very different feel, may well be a very different market to your more traditional physical market. So I think the answer would be legally not necessary, although needs to be certainly an element of reviewing and future proofing, but commercially might well be a jolly good idea, I think.
Okay, thank you. I don't see any other questions that have come in. If you don't want your question read out, then please do send it by email. But I think we are reaching the end of the session. Patrick, do you have any questions for us before we all disappear? Thank you so much for joining and presenting to us tonight. It's been extremely interesting. Sure that Patrick has picked that up. Nick, I would suggest, as we've reached the end of the session and there are no further questions, that we close down the webinar. Thank you very much for joining, everyone.
Thank you, everybody. Thank you. Good evening.